judges. My colleague Tom Sotis and I could not be more pleased with the panel that we have assembled for this webinar, Chief Judge Paul Meyer and Judges Feinerman and Dow. On behalf of the entire Chicago chapter of the Federal Bar Association, I want to thank all three judges for their participation in this program. We had hoped to do this program in person in March, but like so many other things impacted by the devastating effects of COVID-19, we were forced to move the program online. One of the most gratifying things about the Chicago chapter of the Federal Bar Association is the willingness of our outstanding judges to participate in programs like this. If you are not yet a member of the FBA, I would encourage you to join. Finally, on behalf of the entire membership of the Chicago chapter, I want to thank Judge Paul Meyer for her leadership of the court during this challenging and difficult time. I think it's fair to say that no chief judge has been confronted with the challenges facing the court due to the pandemic. I thought it would be helpful to just sort of quickly set the table before turning it over to our more distinguished panelists. When the Supreme Court set the standard for expert testimony admissibility in the seminal case of Dalbert versus Merrill Dow, it was a precedential turning point. However, the current standard, though founded by the Daubert court, is also deeply rooted in its progeny. Referred to as the Daubert trilogy, the two cases that came after Daubert greatly contributed to the final standard used today to admit expert testimony. While the court in Daubert enumerated the factors to be considered when evaluating the reliability of expert testimony, General Electric versus Joyner addressed the appellate standard of review of a trial court's admissibility ruling. Finally, Kumho Tire Company versus Carmichael, the court applied the Daubert standard to non-scientific expert testimony. Taken together, these three cases have crafted the current standard for expert testimony admissibility. Of course, prior to the Daubert decision, the admissibility of expert testimony was governed by the Frye standard. In Frye versus United States, a 1923 decision of the DC Circuit, the court held that expert testimony was inadmissible unless the principle had gained general acceptance in its field. In concluding that the Frye test was superseded by the adoption of the Federal Rules of Evidence, Justice Blackmun in Dalbert wrote, "Faced with a proffer of expert scientific testimony, then the trial judge must determine at the outset, pursuant to Rule 104A, whether the expert is proposing to testify to 1, scientific knowledge that 2, will assist the trier of fact to understand or determine a fact in issue. This entails a preliminary assessment of whether the reasoning or methodology underlying the testimony is scientifically valid and of whether that reasoning or methodology properly can be applied to the facts at issue. We are confident that federal judges possess the capacity to undertake this review." I believe that very few decisions have had as significant impact on civil litigation as the Daubert trilogy. In the 27 years since Daubert has been decided, and I checked shortly before this webinar, it has been cited in federal court cases alone almost 23,000 times and in almost 5,000 law review articles. With that, I will turn it over to my colleague, Tom Sotis, who will kick off the discussion.
Thanks, Frank, and thanks everybody for attending. Thank you, judges, for joining us today. My first question is a bit of a table setter. It's pretty broad, and I'm going to ask it on behalf of a bit of the younger practitioners who I hope are in attendance, and myself, but I hope it'll apply to everybody. When we come out of law school, we are trained to write a motion to dismiss. We know how to tackle a summary judgment motion, at least theoretically, and it's something that we can pick up if we don't know how to do it right off the bat. Daubert is a different animal, and when you get your first Daubert motion, it can be a bit of an impregnable fortress. So you take a look at the opinions that Frank just sent over, and then you open your rule book and you read Rule 702, and it can be tricky. You're dealing with very technical, often scientific topics that I doubt many of us went to law school to learn. So my question is, when we open that rule book and we look to 702 and we're preparing our Daubert motion, we see these four items. Will the knowledge help the trier of fact understand the evidence or determine the fact and issue? Is the testimony based on sufficient facts or data? Is the testimony the products of reliable principles and methods? And has the expert reliably applied the principles and methods to the facts of the case? When you are serving as the gatekeeper on our Daubert motion, which of those factors, of those principles, is the most important or difficult or vexing, in whatever way you want to take it? But which is the one that we as younger practitioners should really focus on, and how can we focus on it to help you in your role and to help us write a better motion? I'll start with Chief Judge Meyer, and then we'll turn it over to Judge Feinerman and Judge Dow.
It's a good question to point out that Rule 12b-6 and Rule 56 are things that people study their first year in law school. And we have the pleasure of working with students here from time to time, often after their very first year in law school. And one of the things that I think they find so satisfying is to see in action what they've been learning about in their courses. Here's what 12b-6 does, here's what Rule 56 is, and here are the distinctions between those two and how they operationalize. Rule 702 is probably not something you spend a lot of time in your first year civil procedure class, and Rule 702 of the Federal Rules of Evidence. And in fact, many of us don't even take evidence till our second year of law school or later. One question I would say is perhaps the least challenging in one way, but the most in another is this going to be helpful to the trier of fact? One would expect that the lawyers aren't going to proffer an expert unless they genuinely believe that the jury or the judge needs to hear from this expert in order to understand the evidence better or to make a determination. But it isn't unusual, in my experience, for people to identify an expert if for no other reason than that they perceive the opponent's going to. And the sense being that we have to have an equal playing field here, and if they're naming an expert, we've got to have an expert on the other side. I'm not sure that's always true. It's not always true. I've seen cases, one, where only one side had the expert and it was the other side that won. So the first and most difficult question really is, will this be helpful to a trier of fact, or will it be a lot of information they really don't need to make the decision? I think that's an important thing to focus on. The other questions too are difficult. Scientific validity, whether the methodology is sound. Those are things we don't, those of us who are not scientists and don't have undergraduate science degrees are really not always that well equipped to assess. But those are important questions too.
Judge Feinerman, what do you think?
Yeah, I agree with Chief Judge Meyer. It's hard to say, though, in the abstract, on a one-size-fits-all basis, which factor is going to be more important, which factor is going to be not as important, or more difficult, or easier. It really depends on the kind of case it is and the kind of expert it is. If it's an expert that is delving into, the finer points of chemistry or biology, then methodology will be most important. But if it's an expert, I had a trial. It was a product liability case involving a table saw. And it was really about, the experts really just spoke from experience as woodworkers, dealing with saws and what works and what doesn't. And there really was not much methodology because it was just based on experience. So if I were giving, you asked the question for the less experienced lawyers. And my advice to them would be the same as my advice to any lawyer who is confronting or addressing a legal regime or a legal issue with which she is not familiar. And that is, go to Westlaw, read the Seventh Circuit's 10 most recent cases on the issue. And then that will give you a sense of the lay of the land, and it will give you a sense of where the landmines are, and it will give you the sense of what's important for the particular situation that you're in. And I think that once you kind of get those signposts, you get the general lay of the land, it will put you pretty far down the path of figuring out how best to approach the motion, either as a movement or as the non-movement.
Yeah, great. And Judge Dow, any advice for the younger folks out here?
Sure. So I think the answer to Tom's first question, as Judge Feinerman just pointed out, is it depends. And that's the answer to most questions that you might ask a judge for pointers on. And to me, Dalbert and Joyner and Kum Ho Tai are really, there's three things you have to look at to start: qualifications, methodology, and fit. And another word for methodology is reliability, and another word for fit is relevance. So you look at those three, and it may be that you have no good quarrel with the qualifications of the expert. So don't spend a lot of time banging that drum. You don't have to oppose the expert on all grounds. If you have one good one, you're probably wasting your time and a lot of your 15 pages challenging someone's qualifications if you don't have a good argument there. You need to focus on whatever your strongest argument is. The thing that a lot of people miss about Daubert that I think is really important is, so if you read Daubert itself, you get these four factors. But you have to remember that those four factors are non-exclusive. They don't have to apply in every case, and sometimes you can't make them apply in every case. Rate of error is a good example. If you're testifying, as Judge Feinerman's example, with someone from experience, you know, it would be hard to compute a rate of error based on experiential testimony. I highly recommend Marissa Tomei's expert testimony and My Cousin Vinny. I don't think you could apply a rate of error to that testimony, but it was probably would have passed Rule 702. The other important thing to remember, and so Daubert itself, if you read the opinion, it tries to draw a distinction between methodology and conclusions. And what Joyner does is link those up. And this is something that a lot of people forget, is you can't put methodology and conclusions in separate boxes. To have valid testimony that you could admit before a jury, you have to be able to connect your methodology to your conclusions. That's a point that Joyner makes. And the main holding of Joyner is, as Frank said, the standard of review. But if you read the opinion, it really talks about the importance of being able to logically connect your methodology to your conclusions. And if you can't do that, then you probably don't have admissible expert testimony. And if you get bogged down in just reading Daubert and you think that's where you should start, you might miss that point. And it's a really important point. To me, it's the most important point, because anybody can concoct a methodology and say, all right, I followed the such and such a test, which is generally accepted, and I reached these conclusions. And if in the middle you've just waved a magic wand, then you're not offering anything useful to the jury. You have to be able to explain why your conclusions follow from your methodology and what the logic is there, in order to do in a courtroom what you do in your normal scientific work. And that's one of the big points of Dalbert. And I can't resist my cartoon here, so I'm going to hold my cartoon up. This is a Far Side cartoon. I hope this works, but this is an example of what you can't do. See that middle step there where the expert says, I have my methodology, and that's the one over on the right near the professors there. And your conclusion is the other side of the blackboard. And in the middle, you have this, then a miracle occurs. You can't let someone testify to the jury that there's a miracle in there, and if you just take my word for it about that miracle, this is good science. That's what you can't do. You have to have that middle step, and the middle step has to work. And a lot of people don't, they overlook that because that's Joyner, that's not Daubert.
I think it's worth pointing out a couple things that, with respect to my colleagues here, Judge Feinerman is correct that one of the best things to do in any new area of the law, let's say you're asked to work on a case that you've never had any experience with before. Read the last 10 cases from the Court of Appeals. I mean, that's what I personally do when I've got something I've never worked on before. Read the last 10 cases from the Court of Appeals. Look around the district court. Maybe one of my colleagues has done something that's useful. Look for those. The other thing is worth mentioning that Judge Dow has particular history with Daubert, and,
right.
and he may want to share that with the audience.
Yes, I
I'd be
think that'd
happy
be a
to do that.
terrific
So
idea, Judge Dow.
the strange thing about it is I knew about Dalbert before Dalbert was a thing. I was a third-year law student, and my father-in-law, who was the general counsel of Merrill Dow Pharmaceuticals, called me. And he said, "Can I talk to you about a few of your professors?" And he asked me some questions about Charles Freed, who was my con law professor, and Charlie Nesson, who was my evidence professor. And after he asked me these questions, I said, "Well, why do you want to know?" And he said, "Well, I have this important case that's in the Supreme Court now, and I'm trying to figure out whether to hire these guys to do the case." And he did end up hiring them to do the case. And my third year of law school, I think it was argued at the end of March. And my third year, I was taking advanced con law with Professor Freed. And for a couple of weeks before the oral argument, he ended up basically trying his arguments out on his class. And there were a lot of really smart people in that class, not me for sure, but Ernie Young, who's kind of the head Civ Pro guy at Texas, was in that class. Adrian Vermeule was in that class. I mean, he had a good group of people to test his arguments out on. And then he went down to Washington. We got a week off and he got to argue the case. And because I knew all this stuff about Daubert when I got to Mayor Brown, one of my big assignments was to get stuck on the breast implant MDL, where I wrote Daubert motions. And I wrote an amicus brief in Joyner where we made the point about connective reasoning being important. And I also worked on Come Ho Tire while I was at Mayor Brown. So I kind of got stuck in Daubert because of my father-in-law. But it's great stuff. And I really tell lawyers all the time, I like Daubert motions because they really are, thinking person's applications of law. They're challenging. They're a real chance to make a huge impact on a case too, because people look at Daubert motions, and if you're a young associate, you get assigned to do a Daubert motion, it might feel to you like it's not as important as Rule 12 or Rule 56, and you've been relegated to the second string. It's like doing a motion in limine. But a Daubert motion, the right Daubert motion can kill an entire case. It can kill an entire MDL. If you knock out the expert who's responsible for general causation, you might kill an entire case. So they can be hugely important motions. And if you get assigned to one, don't feel like you've got put on the second string because they could be really important.
Yeah, no, I agree, and certainly as an English major, it's one of the areas I've truly enjoyed, because I think one of the things about what we do is the opportunity to learn new things, even as a more seasoned practitioner than someone like Tom. Taking it, I guess, to a more practical level, what are some of the things that you appreciate seeing from practitioners in terms of either the written Dalbert motion or the argument itself? And I realize that sometimes we don't necessarily get to argue those motions, and I suppose going forward, and I know Judge Meyer addressed this in her State of the Court address, that one of the cultures of our court is the ability to see our judges frequently, and I fear and I know that's going to change in the short term. But what are some of the practical pointers you can give? And maybe Judge Feinerman, we'll start with you.
Sure. I would give two pieces of advice if you're drafting a motion. One of them is something that Judge Dow said a few moments ago, which is you don't have to cover the field of all the considerations if they don't fit. In other words, if the expert is qualified, clearly qualified,
Right,
don't challenge the qualifications, because as Judge Dow said, it will eat up part of your 15 pages. And second, it will diminish your credibility. It will look like you're just throwing spaghetti on the wall and hoping that a strand sticks. Focus in on the truly contestable aspects of the expert that you're trying to knock out of the case. The second thing is to find a happy medium for explaining the hard science, if in fact a Daubert motion calls for hard science. And I say try and find a happy medium. What I mean is don't assume too much knowledge and don't assume too little knowledge. And as I'm saying that, I realize that that may be an impossible task because you don't know how scientifically inclined, or you may not know, or you likely won't know how scientifically inclined your judge is, and in particular, how scientifically inclined your judge is in a particular area of science. So it's a hard line to walk, but if you assume too little knowledge and you approach the motion like you're talking to, a middle schooler, you might lose the judge's attention. But if you assume too much knowledge and you don't explain the basics, all your great arguments are going to go over the judge's head. So if you can, again, it's very hard, but it's something to think about. And I think your baseline assumption could be, unless you know something specific about the judge, your baseline assumption about the judge should be that the judge is an intelligent layperson that has some basic background in science, but doesn't have a degree in science, and take it from there.
Judge Paul Meyer, you've moved, but I'll put the question to you.
I made a point of coming into my office so I wouldn't lose a connection, and somehow I lost a connection anyway, but I'm back. And it moved it to a different location in the office. I heard most, I think, of what's been said about tips. I would suggest first that, there are differences of opinion about how Daubert motions should be decided. And I think usually the safer course is for the district judge to rule in writing on the Daubert motion. I mean, we don't always do that. Sometimes we do it from the bench. And certainly if it's a bench trial, we're more likely to do it from the bench. And I want to drop right now a footnote here and point out, there's no mystery about our situation here in the Federal District Court. We have big challenges in the next several months due to the need to separate people and keep them safe. And what that means, for good or ill, is that it will be much, much easier for us to conduct bench trials than jury trials in the foreseeable future. And I say that with some trepidation because I am, like many judges, vastly prefer a jury trial. I'd much rather have the jury do the hard work of sorting out who said what and what the causation issues are and who should win. But the reality is it's going to be difficult for us to assemble a jury and do that safely in the next several months. And we'll make every effort to make it work, but you may find a lot easier going if you opt for a bench trial. Again, to return to the issue of Daubert motions, I think it's the better course is to write something. In fact, just looked at some cases this morning, and I see at least some hint in the Court of Appeals that it's much easier for them to review a decision that's well reasoned in writing as opposed to more or less on the fly. It isn't unusual. I know Judge St. Eve, when she was a trial judge, would routinely assume she's going to have a hearing on a Daubert motion. You don't always have to do that. We can rule based on the papers, on the submissions. It's not required to have a hearing, but a hearing can be very helpful. Sometimes it really helps to hear that witness, even if it's by video or telephone, to hear that witness present his or her conclusions and have an opportunity to question those conclusions can be very useful in making a determination about whether or not the methodology is sound, whether or not, if the person's using sort of an ideological approach, that he or she has ruled out other relevant possible causes and the like.
Judge Dow, I guess you're our expert on experts, given your history.
Well, I would say everything that both Judge Feinerman and Judge Paul Meyer said I would agree with. And I think you can go through the trilogy and then you can go through the 20 years of Seventh Circuit cases since then and have a pretty good idea of what the boilerplate law is. There's no sense in really drilling down on that. You also could, the three of us have, a lot of opinions out there on Dalbert too. And remember, the standard review is going to be abuse of discretion unless we make an error of law. And given that there's 27 years of law and it's been pretty well settled, at least since Cum Ho Tire, what the law is, it's unlikely that we're going to make an error of law. So my recommendation is, if you're going to do a Daubert motion in front of me or anybody else, to read our Daubert cases. I mean, there's lots of cases out there you could read of mine, and you could see exactly how I approach it. And there wouldn't be any reason to say much more for the legal part of your brief as to say everything you said on, pages 1 through 5 of your last opinion about the law. We agree with that, and just do a very simple summation of what the law is. A lot of people spend 5 pages giving me case after case after case on qualifications, methodology, and fit. You could do that in a paragraph and then start applying it. That would probably be more effective. What would be really effective is if you found other cases, even if they're from another jurisdiction, that actually apply precisely the problem you're saying this expert has. And you could say, and 3 other judges have looked at this and they've concluded that this is a flaw that justifies exclusion of the expert. That would be better than giving me 5 pages of the boilerplate law about Daubert. And because the standard review is abuse of discretion, and because we all have our own ways of doing things, it's definitely worth, in addition to reading those 10 cases from the 7th Circuit, you ought to read 5 cases of mine, or Judge Feinerman's, Judge Pallmeyer's, whoever your judge is, so you can get a sense of how they approach Daubert issues.
So, Judge Dahl, I'll keep the pressure on you here, because there has been, speaking of finding opinions elsewhere, I mean, that's what we do. We try to find opinions, try to analogize. But there has been some specific criticism in the Daubert space about, we'll use the word allegedly, as lawyers often do, an allegedly inconsistent application of Daubert and Rule 702, different federal courts across the country. And another criticism often lodged in tandem with that is a sort of a judicial disinclination to grapple with some of the difficult scientific and technical issues that this panel has very clearly said engage with those. But there has been some criticism about judges more or less punting on those and sending it to the jury without making a decision on that. So there is currently the Judicial Conference Advisory Committee on Evidence Rules is considering amending Rule 702 so that it will explicitly state that expert opinion is only to be admitted when it's supported by preponderance of the evidence. And I'm wondering, Judge Dow, and then Judge Pallmeyer and Judge Feinerman, if you think that amendment would help the Daubert regime, would it address those criticisms? Do you think those criticisms are well-founded? So a lot to take in there, but I appreciate your thoughts on it.
So I guess I've always thought that preponderance of the evidence is the standard, and I'm surprised there's any dispute about that. And I remember doing these 150-page compendium of case law under Dalbert when I was at Mayor Brown. We sent around to every single lawyer who was going to try any case for Dow Chemical or Dow Corning in the breast implant cases. And that seemed to me established in 1995 when I was starting to write that. So I'm surprised that that's an issue. Is there a variation between judges? Sure. Some judges really want to dig in on this. There may be judges who also are more inclined to think that evidence should be excluded, and more judges who would prefer to kick it all to the jury. And you do have appellate review. And one of the issues that the Civil Committee is looking at is whether you ought to have an extra avenue for appellate review and on bigger cases. MDLs is what we're looking at, but there may be other cases where expanding review under 1292B would make sense for a bet the company issue like general causation in an MDL that has 6,000 cases. But I don't think you're ever going to be able to stop the differences between judges, and especially on an issue that's ultimately reviewed for abuse of discretion. I mean, it's really you could add a little wrinkle into the evidence rule that would codify what I think is the general rule of preponderance of the evidence is the standard. But as long as it's reviewed for abuse of discretion, you could find 2 judges who come out very differently on an issue and they both get affirmed. So it's only an egregious error that's probably going to get corrected on appellate review. and you can't standardize the practice for 900 judges on things that are it's just like sentencing. You'll never be able to make that all the same either, unless you go back to a regime where you take the discretion away. So I think my sense of the rule, and I don't know too much about the rules proposal, is it really would be tweaks at the margins. I don't think it would be a revolution. Daubert was a revolution. And that was all codified in the rules. I think in 2000, there were amendments to the evidence rules that pretty much codified the case law up to that point, or maybe it was 2002. I think what they're talking about doing now, it would be nowhere near that in terms of how it would affect practice. But I don't think it's going to root out discrepancies in how judges view these issues.
Judge Palmer, do you have any thoughts on the topic? I know Judge Dow went pretty in depth there. So.
Yeah, I would just point out some changes in the federal rules make a big difference in practice, and other changes in the federal rules I think are tweaks. And I would characterize the preponderance in the same way that Judge Dow did. I mean, I think we would have assumed preponderance was a standard, and we here in the Northern District like to think that we get the best court in the nation. Of course, that's what we think. But for example, when a couple of years ago, the rules were amended to say that discovery has to be proportional. This was sort of a sea change, and I think the rest of us were thinking, well, of course it's supposed to be proportional. We've always done that. And by the same token, the rules will establish, well, you should have a Rule 16 conference and do some planning and make sure that people have a schedule. Well, yeah, we always do that. So I mean, I would characterize the preponderance rule as a good idea, but I don't think it'll affect a sea change. At least I don't think it'll affect a sea change in the practice here. And I don't mean to interrupt, Gary. I don't know if you had Judge Feinerman, if you had something to say on that.
No, I agree with what you and Judge Dow said about that. But there is variation among the judges, not just in the outcome, but in the appetite for wrestling with the science.
Yes.
And that's why it's important to present the science in a way that is understandable to an intelligent layperson. And that's the best way you're gonna be able to get your non-scientifically inclined judge to really engage with the material.
Well, let's talk a little bit about timing of Dalbert motions, because I think that's something that we often, as practitioners, struggle with, and I think different judges in the district may have different preferences. But for example, whether it's a summary judgment motion or a class certification motion, I think as Judge Dow alluded to earlier, I mean, it could very well be an integral part of the summary judgment motion or opposition to class certification. I think some judges don't like in seriatim motions. So in other words, do you bring the Dalbert motion first, or do you file it in conjunction with either an opposition to a summary judgment motion or a motion for class certification or opposition to class certification? Judge Feinerman, any thoughts on the timing and what your preference is?
I don't have a preference. Well, I do have a preference. The Dalbert motion should not come after the summary judgment motion or the class certification motion if the expert is central to either of those things.
Right.
But in terms of whether Dalbert goes first and then summary judgment, I don't have a preference except for this one point. If you want to do the Dalbert motion first, make sure you do it well in advance of the dispositive motion deadline, because what most judges, I think, probably would not be too excited about is you hit the dispositive motion deadline and then the move-in says, well, let me first do the Dalbert motion and then we'll do summary judgment. That would knock off the schedule, and you might not be successful in staging things like that if you wait until later on in the case. But most of the time, in my experience, and maybe Judge Meyer and Judge Dow's experiences are different, you get simultaneous briefing on the summary judgment and the Daubert, where the summary judgment motion is filed by the defendant, and along with that is you get a Daubert motion against an expert that is critical to the plaintiff's cause of action, and then you just go forward with both. And then if the essential expert is knocked out, that makes the summary judgment easy. If the essential expert survives, then maybe the summary judgment motion will present other grounds for summary judgment other than the expert being knocked out.
Judge Paul Meyer.
Well, I of course think that those observations are important. Obviously, this is one of those it depends kind of a thing. If you're, just as a really, fairly straightforward example, if your expert is an expert on damages and the defendant's moving for summary judgment on liability, you don't want to spend a lot of time on Dalbert until we know whether the plaintiff's going to survive the liability challenge on summary judgment. On the other hand, if your expert is an expert on causation, without that expert, the plaintiff can't proceed in a medical case and some other cases of causation, then clearly you want that decision to be made certainly no later than summary judgment, and ideally earlier, because if you, for example, can't get your expert qualified, but you maybe can proceed in some other way to establish the element of a cause of action you need, you want a chance to kind of regroup and figure that out. So it really does depend on how you're going to do it, on what order you're doing things in. At a real minimum, I've got to say that if your case has survived summary judgment, you're going to trial, and you are preparing that final pretrial order, and you've got a bunch of motions to eliminate, the judge is probably not going to want a couple of big Daubert motions in there too. I mean, we realize it happens, but we'd rather have that ironed out already.
Judge Dow.
Those are all really good points, and I think it underscores the importance of thinking about your experts and what testimony you need to prove your case or defeat the other side very early. The scenario that Judge Meyer was outlining is one that we encountered a couple of times at Mayor Brown, and there's a case called the Weissgram out of the Supreme Court. I don't remember what year, it's in the early 2000s, but that's a case that basically holds that if your expert gets excluded, you're not necessarily entitled to a second chance. And so you work up your case, and lo and behold, your expert's gone. You have nobody to vouch for general causation or some dispositive issue, and your whole case is gone. And that's why Judge Meyer's point that you might want to think early about your experts, and even on the plaintiff's side, propose Dalbert motions early enough that if they don't go your way, you might be able to save your case or even proffer a second expert.
Mm-hmm.
A judge will be much more inclined to give you the time of day on that 6 months or a year into the case than 3 years into the case when you waited and Dalbert didn't surface until 2 weeks before the trial and your expert got excluded 1 week before the trial. That's not a good time to ask for another expert or another way to save my case. And I think too many people think of it in terms of discovery, fact discovery, then expert discovery, and you don't even think about it until it's too late probably to do something about the problem you might have. So it's really a sort of as a lawyer giving advice to your client, you ought to be thinking about all these issues from the start, and 3 months or 6 months into the case, have your plan A, which is to go with this expert. Plan B is maybe we have a second expert in reserve. And plan C is, what if all our experts get bounced? How can we still get in front of the jury? All those are things that you're better off thinking about early to give your client the wiggle room to react to unexpected decisions or unexpected developments. I mean, you can't control the science either. So your expert thinks X, and then a year later, a great epidemiological study comes out that casts doubt on your expert's theory. You better have Y, or you're going to be in trouble.
All right, I'm going to jump in really quick for the attendees. Everybody pay close attention. I'm going to announce the CLE code for today's program. You also you're going to need to download the attestation form and the evaluation form, which should be in the handouts section of the little webinar. I hope I'm pointing the correct way on the screen to the little webinar thingy. So download those, and then the CLE code is rules, R-U-L-E-S, rules, like the federal rules of evidence. So make sure you get that if you want CLE credit for today's course. And you have to download those forms while the webinar is still going. So download those now in order to get credit. So I'll jump back into the Daubert topics. And I'm struck by a lot of the conversation today about the need to tether the science to the conclusion and the line that lawyers need to walk when drafting their motion, to not bog themselves down in the science, but make sure there's enough in there to let the judges know what it is that's going on. And Judge Dow, I know I've heard you talk, you mentioned us the other day about a science day, and I'm wondering if you could expound on that, or if judges, if you could offer any advice to practitioners for how to walk that line. And I know it's difficult, as Judge Feinerman said, but ways to make sure that the judge, that they have some sense of what they're reading, particularly in scientifically complex and technical cases.
Sure.
Judge Dow, you
So
want to talk?
it's a bit of an innovation it's common in patent litigation. It's also common in big MDL cases where the lawyers will come in early in the case and propose to the judge a tutorial or a science day. I know we've all seen these in patent cases too. And what happens is each side comes in and the judge says you can each have an hour or 2 hours or whatever. Sometimes it's done with a PowerPoint. Sometimes it's done by the lawyers. Sometimes it's done by the experts. I had a science day once on a color case. It was two printer companies were suing each other. And the two guys who came in for the science day were both British octogenarians. And they were great. They had these accents that were very pleasant to listen to all day. And they talked to me about color science, which I knew absolutely nothing about. But at the end of the day, at least I could sort of speak the language, and they were able to take complicated concepts and give me an analogy to something I could understand. And at the end of the day, at least I felt like I had a glossary of terms for what I was about to see in all these briefs on claim construction and summary judgment and everything else. And it's really borrowing something from the patent bar, which does this a lot, and the MDL bar, which gives you an introduction, like you'd have a science day on whatever it is, whether it's Zantac or opioids or whatever the issue is. You'd have some people come in to get the judge up to speed. I know I'm a history major. I think Judge Pallmeyer is a history major. Judge Feinerman, what are you, political science?
Poli-sci.
Okay, so we might need some help with color science. But it's a great thing, and it's fair to both sides because each side gets an hour or 2 hours or whatever. But it's a way to learn on a crash course on something that you're going to be living with for the next whatever it is, depending on the complexity of the case. You don't have to do this if it's Marissa Tomei and my cousin Vinny, but you do have to do it if you've got something that's going on for 5 years and you're going to be living with this through 1,000 docket entries.
Yeah. Judge Pallmeyer, do you have any thoughts on whether it's a science day or ways that folks can?
I love science day. I was a history major, but I came close to majoring in biology. I like science a lot, and I think it's just great when you have an expert who's good at it. There are a variety of experts. We haven't talked about that so much, but the rap on some is that they're hired guns and they're very arrogant. But then once in a while you get people that have never given expert testimony before, and they're a little green, and those can be very appealing. One of my better experts was a professor who'd never been an expert witness before, but he gave a great discussion of it was a chemistry issue, and he wanted to show the jurors. We'd already qualified him. He was coming in. He wanted to show the jurors how something worked, and he had his graphs and his charts, and he put them up before the jury, and he lectured, and then he turned to the jurors and he said, "Any questions?" Which of course both lawyers jumped up and said, "No." But I mean, that's the kind of expert I enjoy, because he's the person was really into it and very interested in making sure we understood. But you know, jurors aren't necessarily the same as judges. What works well for us at the Daubert hearing stage might not be exactly the way you want your expert to present when he or she's talking to the jurors. That's something to be sensitive about too. But I like Science Day. That's always really fun for me. And we hear experts a lot in the Markman context in patent cases where we're doing claims construction. And you know, a good expert there can make a tremendous difference. Sometimes the way the claim gets construed is the whole ball of wax. So you're going to win or lose your case based on my claims construction. You want to make sure the expert explains things very well.
Well, Judge Feinerman, I know this struck me because you were talking about walking the line on making sure that the judges know what they're dealing with. And if you have any suggestions, if you thought about that on the last half hour about ways folks can do that, their Daubert motions and in their experts, we'd love to hear it.
Right. I mean, I second what Judge Dow and Judge Paul Meyer said about Science Day. It's very helpful, especially if it's really hard science, or even moderately hard science. It's very, very helpful to get. You want the judge's attention because we each have hundreds of cases, and we have to tend to all of our cases. And if you can get the judge's attention for 2 hours or 4 hours or 6 hours, that's very valuable real estate on the judge's calendar. And so if you're going to have a Science Day, you'll definitely want to make it worth the judge's while. And it will. If you do teach the judge something that an intelligent layperson, non-scientifically inclined, would not otherwise know, but that's important for the judge to make intelligent rulings in your case, it's absolutely a good way of doing it. So, there's Science Day, and then there are some lawyers who are just gifted in terms of understanding the science, but also understanding how to teach it to somebody who's not scientifically inclined. And some lawyers, as with most anything in the law, some lawyers are really good at it and some lawyers are not as good at it. And it's just, it's hard to come up with a one size fits all advice on this. But if it's truly an exceptionally difficult area of the law, do ask your judge for a Science Day and have some experts come in. Or if the lawyers are really good at science, have them come in to explain the science to you.
I think we have time for maybe one more discussion, and then I think we have one question. And I guess following up on a little bit of what Judge Meyer just talked about, I know we've kind of focused on tips for practitioners. What about the experts themselves? I mean, I'm sure we've all had the experience and practice of the expert who refuses to answer a question or concede even the most basic point. What are some things you've seen from the experts themselves that have either proven very helpful or that have made your job more difficult, Judge Feinerman?
Yeah, I mean, you hit on one of those points, which is, and it's the same for lawyers as it is for experts, to be able to make strategic concessions. You don't have to win every battle as a lawyer to win your case. And as an expert, you don't have to win every point in order for your view of the issue to prevail. And if you're a dead ender on every single issue, including the issues that don't matter, and you're just as you can improve your credibility by just acknowledging certain things, it's important for the expert to do that, whether it's a Dalbert proceeding where the judge is going to be making a decision, or whether it's at trial when the jury is going to be making the decision.
Dow?
I would agree with all that, and I would say that some of the most useful expert testimony I've had is when the expert can not only explain his or her own bona fides, but also can explain where the other side's expert falls apart. Because sometimes it's hard for the lawyers or the judge to spot the flaw where someone who's been immersed in a field for 40 years can say, oh yeah, you want to ask me about the other person? This is their problem. And they can spot the flaw. And if you've got the expert who says, not only am I good, but they're bad, that's an expert who's given you whatever they build you, they ought to be able to bill you twice because they've carried the water on both ends. And I've had experts who were able to do that. And it's, that's someone you really know knows their stuff.
Judge Meyer.
I generally enjoy hearing experts. Once in a while, they'll convey the sense that they really hate to have to spend their precious time in court. And you really want your expert to get past that, to be pleasant about the fact that we're relatively uneducated about their field and we're going to need, some help with it, and it might take some time. Like any witness, you want to prepare the expert well. You don't want them to come across as arrogant or brusque. It always helps, at least it helps me, if the expert is prepared to illustrate things physically or with an object or a drawing or a PowerPoint, or sometimes animated video about how some product works. Remember that we all learn differently. Some of us learn very, very well by reading text. Others really need an illustration or a document. Others need both, or need some kind of a video demonstration in order to bring it alive. Keep that in mind, because you don't know necessarily, again, your audience, at least at the Daubert hearing, could very well just be a judge, but ultimately the audience could be jurors, and their needs and ways of learning might be different. So that's something that a good expert is going to understand. It doesn't necessarily require this person to be a traditionally hired expert, one who's testified many times. It can be somebody who's never done it before, as long as he or she is a good communicator. That can work just very well. If you do have an expert who's been disqualified in the past for one reason or another, be sure to address that head on. Have the witness explain right away why this case is different and what was missing in that case is not missing here, or what happened improperly there won't happen again. Make sure you're upfront about any expert that's been disqualified, because the other side will make mincemeat out of that otherwise. In kind of a silly way, they'll really go all over an expert who's ever been disqualified. So be ready for that. Just as you would in any case, if you've got some bad information, it usually helps to front that with the witness rather than waiting for it to come out on cross-examination.
We have one question from our audience. If a highly qualified expert says this condition has been caused by other factors and other populations, so it is my opinion that it happened here, is that methodology objectionable under 702? Anybody want to take that question?
It's like a law school exam question for the judges. This is great.
I think I'd really need more information.
Yeah, there's not enough information to answer that. It depends on what the methodology is.
Right.
And it depends on what other populations, what does other populations mean? And are there significant differences between the population of the plaintiff and the population that the expert is familiar with?
That's you're taking me back to laboratory studies of breast implants, and whether you can extrapolate from a mouse or a rat to a human, and how many, and there's a lot of biology involved in that you'd have to know before you could say. But it's the same question. What's the basis for making the comparison? What's the basis for the extrapolation? What supports the reasoning that you get from point A to point B? That's the same fundamental question. We just don't know enough information to answer that question on that hypo.
One other question just came in over the wire, do you think lawyers file too many Daubert motions? How should lawyers evaluate whether and when to file such a motion? I hope we had covered the second half of that question, but in terms of too many Daubert motions, anyone want to take that one?
I don't think lawyers file too many Daubert motions. Sometimes I think they name too many experts. But, you know, if there's a Daubert motion that has some teeth, I think, you know, that's pretty important. I'd want that motion to be presented and briefed well before I make the mistake of letting some person testify before a jury that shouldn't be on the stand.
One other question, which I also think we've covered. I hope people have been paying attention. What are the key elements that make a persuasive Daubert motion? I think we've kind of covered that. And then lastly, we know the court's gatekeeper function is not designed to supplant the adversary system. How does the practitioner make clear that an expert's testimony is inadmissible as opposed to being weak but admissible evidence? I guess that'll be our last question to end this terrific session. Judge Dow, you want to take that one?
Sure, that's a very fine line, and I think if you get to the end of some of my Daubert opinions, you'll see that that's the line that I sometimes draw. And you know, I don't know if there's any magic to that. There isn't any head note for a West that I could type up that would say, well, here's, if you have this, then you've knocked out the expert, rather than having the expert just be weak. I think that it may have been Daubert itself that said that the point is not to in borderline cases, it's subjecting the testimony to rigorous cross-examination is the way to sort it out and not to exclude it for the judge. I think that is a line that a lot of judges follow. So we're reluctant to knock it out altogether. But remember, the whole point of Daubert and the whole point of Rule 702 is that we do have that gatekeeper function, and we can't let the jury hear evidence that isn't appropriate. So at some point, you do have to pull the trigger, and that may go back to the question before about the discrepancies between judges, and you're never going to wipe that out. And so I guess all I can say is I'm very cognizant of that line, and I know on the one hand I'm supposed to let borderline testimony through to be subjected to the crucible of cross-examination. On the other hand, I can't let everything through because it has the potential to sway the jury in ways that is inappropriate because someone has the mantra of being an expert.
Right, but what you can't, I agree with everything Judge Dow said, but what you can't do as a judge is to exclude an expert because you disagree with that expert's conclusion.
Right.
Because you're going to have, when in cases with dueling experts, you're going to have the plaintiff's expert saying, for example, there's causation, or the product does X, and then you're going to have the defendant's expert saying there is no causation or the product doesn't do X. And it's up to the jury to sort it through, and what the judge is there to do is not to decide who's right and who's wrong. What the judge is there to decide is which expert is doing the work of the expert that is required by Rule 702. In other words, is qualified, has a sound methodology, and connects the methodology with the conclusions. And if the expert clears those hurdles, then both of them go through, even if only one of them could be right.
Well, I want to thank all three of our judges. I think this has been a terrific program and very insightful. And we certainly look forward to seeing all of you in person at some point in the in the future, maybe the distant future, given what's going on with COVID. But I want to thank everyone again. Encourage folks who are not members of the FBA to join. It's a terrific organization, and as I said at the outset, what makes it a terrific organization is the participation of our wonderful judges in the Northern District. So thanks again to everyone, and I think there's a couple of programs upcoming, and they're all posted on the FBA Chicago Chapter website. So thanks everyone, and again, thanks to our terrific judges. Thank you.
Thanks
Thank
everybody.
you.
Have a great 4th of July.
Thank you.
Yeah.
Be well.